The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this Honorable Court.
Thank you very much. Welcome to the Fourth Circuit. Please be seated. Rachel, can you come up for a minute just before we get started? All right, we're ready for argument in our first case, United States versus Shivers. Mr. Carpenter.
May it please the court. We are asking you to hold that the undisputed facts of this case do not satisfy the substantial risk standard under 3C 1.2. The bottom line in our view is that the act of discarding a firearm de-escalates and decreases the overall risk present in the situation. So that act, standing alone, cannot be enough to justify the enhancement. The analysis in this case begins with a background principle. In seeking to apply an enhancement, the government bears the burden of proof. And here, the only evidence that the government submitted to sustain this enhancement was the undisputed statement of relevant conduct present at Joint Appendix 142 and 143. And the only statement or assertion in that document related to the flight was that the officer saw Mr. Shivers discard the firearm. So the question, put simply, is whether that act, without more, justifies the enhancement. And we believe it does not. The government defends the enhancement based on three separate theories. One arising from the handling of the firearm, one arising from a risk of discharge when dropped, and the third arising from a risk of abandonment in the community. Each of these is insufficient. So if we start with the handling of the firearm, the government on that theory relies primarily on the Dennings case. But the two key facts that were established in the Dennings case are not present in this case. The first fact in Dennings was that the defendant there handled the firearm during flight in a way that was provocative, that caused the officers to believe there was a possibility he was about to draw the firearm and use it. That action created a risk of the officers firing in self-defense that could have harmed either other officers or bystanders in the area. The second fact that was present in Dennings that isn't present here.
So if the defendant had thrown the firearm at the police officer or at some other person, that have been sufficient?
Most likely, Your Honor, yes. If there was something about the manner in which the firearm was thrown that went above and beyond simply tossing it onto the ground, then it was incumbent upon the government to allege whatever that aggravating fact was, and then we could have analyzed whether that aggravating fact was sufficient. Certainly throwing a hard metal object like a firearm at someone itself creates a risk, regardless of whether it's a firearm or some other hard metal object. That would create a risk of harm simply by the act of throwing it at someone. So again, the government did not allege that fact. They did not allege anything about the manner in which he threw it.
Was there any testimony by the officer or some other witnesses to the likelihood of discharge based on the type of firearm?
Your Honor, was the question, is there testimony in this case about that?
Correct.
There is none. Again, the only evidence that the government put in to support this enhancement is at Joint Appendix 142 and 143. It is a statement of relevant conduct. The facts in it are undisputed. There was once we objected to those facts as being sufficient, the government had the opportunity at the sentencing hearing to marshal any additional evidence it could have to put on the type of testimony, Judge Agee, that you're suggesting. The government declined to do that. That leaves this court with the simple question, does the single undisputed fact in this document that the firearm was discarded in plain view of the officer justify the enhancement? And
so
again,
page 142, there's paragraph 17. Officer Crum noticed the suspect throw a silver revolver in the street as he ran toward Grove Street. Firearm was later recovered and determined to be a Taurus 357 revolver. Is that it?
That's it. The question before this court is, does that single paragraph support this enhancement. And our position is that because the mere act of discarding is de-escalatory, it eliminates two possible risks, the two possible risks that were present in Dennings. By putting the firearm on the ground, that tells the officers in pursuit that this defendant is not going to fire at them. So one risk eliminated by the discarding. The second risk that was present in Dennings, the firearm remained in the defendant's pocket at the time of a struggle when he resisted arrest. As Dennings pointed out, that creates a risk of accidental discharge during the struggle. By putting the firearm on the ground, that risk is also eliminated. And so it all comes down to the simple proposition that putting the firearm on the ground decreases the overall risk. So that action, the only action the government has alleged, cannot be sufficient to justify the enhancement.
May I ask you a question about the recklessness mens rea?
Yes.
What you're arguing is that the safest thing under all the circumstances to do in a situation like this is put the gun down, and that's what happened here. If that's right, can that be reckless? Can you recklessly decrease the risk of a situation?
No, Your Honor, I don't think so. I think that, our argument has focused primarily on whether the risk was substantial,
Right.
but I agree that there is also a real question about whether it was reckless in this circumstance, because what we believe here is that what the government's asking for is effectively a bright line rule that the mere act of discarding is enough. And I think that bright line rule is misplaced because it overstates the risk by assuming that officers are unable to distinguish the circumstances in Dennings where the actions are provocative and the circumstances here where all they see is a discarding of the firearm. I think officers are perfectly capable of making that distinction. The other thing that the bright line rule does is it creates really perverse incentives because we want defendants who are fleeing to get rid of the firearm because it decreases these risks. And under the government's bright line rule, there would be no incentive to do that. In other words, the bright line rule fails to distinguish between two significantly different amounts of risk. The risk in Dennings is much higher because the firearm, because of the reasons we've talked about here, putting it on the ground decreases those risks. And the point of this enhancement is to distinguish between greater risks and smaller risks. And again, that ties back into the commission using the word substantial risk. If the commission had used any risk or any unjustifiable risk or any other formulation, we might have a different question here. But the word substantial means, according to the dictionary definition, present to a large degree. Because of that, we cannot justify this enhancement based on small risks. So the second theory that the government uses for justifying the enhancement is that there was a risk of accidental discharge from the mere act of dropping. We think that risk isn't present on the facts of this case for really two kind of separate sets of reasons. The first is there is no allegation that the gun was in a condition where it was ready to discharge. For example, being cocked, having a safety off, or any other evidence that would show that merely hitting the ground could cause a risk of discharge. All of the cases, like the Mukes case and I believe even the Lard case in the Seventh Circuit that talk about this risk of accidental discharge from dropping, apply that theory only if there is evidence in the record that the gun is in a condition where it's ready to fire. That evidence simply isn't present here.
Mr. Carpenter?
Yes.
With regards to the gun, it was loaded. What about the risk of someone picking it up in the area? That was another concern raised in the case.
Yes, Your Honor, that is the government's third theory, the abandonment theory. And the reason that I think that risk isn't sufficient on the record in this case is because there was, again, in the undisputed statement of facts, there's a perimeter established around this area, and the gun was dropped in plain view of the officer. So that puts this case on all fours with respect to abandonment as the Mukes case in the Sixth Circuit, where they said, look, even if there is in theory a risk of abandonment, for example, if it's dropped in, a preschool, an elementary school playground, that's a very different situation than where it is dropped in front of a pursuing officer in plain view, particularly here where there's a perimeter established. In that scenario, there's really no risk, much less a substantial risk that a bystander is going to come across the firearm. So that theory, and I would note the district court did not rely on that theory. The government does raise it again, as it's allowed to do, but I do not think the evidence in the case supports it. The other point I want to make about the risk of accidental discharge, aside from the evidence that or the lack of evidence that the gun was cocked or otherwise ready to fire, I would point the court to the expert opinions that included in that Washington Post article that we cited about the Alec Baldwin shooting. It is simply a myth that modern firearms are at any real risk of discharging simply from being dropped on the ground. It's a myth. It comes from popular culture. It comes from cartoons like, Yosemite Sam and the old Looney Tunes stuff. We see it all the time, and it seeps into our brains that that's a real risk. It simply doesn't exist in the real world with modern firearms.
You didn't tender any evidence to that effect.
No, but it's not our burden to do so. And the government also has not tendered any evidence to say that a modern firearm, in fact, if you look at the government's brief at page 22, they effectively concede this point in saying that, that we are correct, that additional steps such as cocking the firearm would be necessary, and pulling the trigger would be necessary for the firearm to discharge. They say, well, but there is also a risk of a malfunction. But that risk, whatever risk there is of a malfunction, is not enough to meet the substantial risk standard. And the government certainly hasn't introduced evidence that modern firearms malfunction frequently enough to create a substantial risk as opposed to a merely theoretical risk. And again, the commission used the word substantial, and we have to give it meaning in the analysis.
So if the government qualified the police officer, for instance, as a firearms expert based on experience and training, and he testified or she testified that based on their experience with this particular type of revolver, it was subject to accidental discharge, would that have been sufficient?
Absolutely. Of course, we would have had the opportunity to cross-examine to try to probe whether that is a valid and strong opinion. Assuming that we go through the adversarial process and the district court finds, as a matter of fact, that expert is sound, then we're in a different scenario. The government didn't do, of course, any of that in this case. The final point, I'm happy to answer other questions, but the final point I would touch on is the government also briefly makes a harmless error argument in this case. I think there are two good reasons to reject that. The first is that the district court specifically declined to enter an alternate sentence when given the opportunity to do so. That by itself, I think, is enough for the harmless error argument to fail under this court standard, which requires confidence that the court would impose the same sentence. The district court specifically declined to say it would. I think that tells us that it is reserving the possibility of doing so. And the second point on that is that the rationale that the district court gave for its small variance in this case is one that would apply based on the lower guidelines range as well. The court relied on two separate factors. One, that this enhancement was somewhat overstating the seriousness, but it also relied on the defendant's history and characteristics, in particular his rehabilitation evidence during his imprisonment. That factor, of course, would remain present and could justify potentially a small variance from the correctly calculated guidelines
So if
range.
the district court judge here, in answer to the United States question, would have simply said, yes, I would find the 3553 sufficient to have imposed exactly the same sentence. That be enough?
Most likely, yes. Much to my chagrin, that is what this court's case law generally holds, that if the district court makes a statement like that on the record that it would impose the same sentence, that at least satisfies the first prong of the harmless error test. The second prong would require proof that that sentence is substantively unreasonable.
I take it your argument here is that the court didn't say that.
Correct. The court didn't say that. In fact, the court specifically declined to say that. He said, I will say that the guidelines were not a significant factor, but he didn't say they were no factor at all. And we acknowledge they weren't a significant factor. We're under no illusion that on a remand in this case, we're going to go from 114 months down to 50 months. But we do think we could go from 114 months, 6, 9, or 12 months lower based on the correctly calculated guidelines range. And that is important to Mr. Shivers. And that's why we believe that the remand is necessary and that the harmless error argument must fail. If there are other questions, I'm happy to answer them. Otherwise, I'll yield the remainder of my time until rebuttal.
All right, thank you. You've got some rebuttal time. Mr. Enright, you must have edged out Ms. Ray this morning, but we're glad to have you. So go right ahead.
Thank you, Your Honor. May it please the court, Anthony Enright for the United States. The district court properly applied the 2-point enhancement for reckless endangerment during flight. I want to point this court to a portion of the joint appendix that my friend, I think, overlooked. because there's a little bit more to it than just on page 142. There's also page 160, which is the probation officer's own assessment of the evidence. And the court said, when he is referring to this is the probation office, but it's a statement accepted by the court and, as Mr. Carpenter mentions, is undisputed. When he, Mr. Shivers, did come out of the store, loud, clear commands were given to Shivers to get on the ground while law enforcement pointed firearms at him. The defendant disregarded those commands and fled from authorities while armed. And what the defendant has conceded is that he did that while armed with the gun in his hand, not hidden from view, not safely holstered, not in his jacket pocket, in his hand. Furthermore, during flight in a congested area of downtown Asheville, Shivers threw his firearm in the street. Now, the reason I read that and emphasize that is because it places this case on all fours with this court's presidential decision in Dennings. In Dennings, the court said the defendant ignored repeated commands from a police officer to stop running, just like Shivers. Continued to flee on foot while armed with a loaded weapon, just like Shivers.
Weren't they fighting over the gun in Dennings?
There was a factual statement in Dennings that said the defendant fell on the ground and the police officer ended up on top of him, and then they struggled over the firearm. But what this court held was this conduct before that altercation occurred was, in this words, this conduct satisfies 3C 1.2. And this court repeatedly emphasized what was significant was the fact that he had the firearm in his hand, what he was doing with his hands in that firearm, regardless of whether Dennings was carrying the firearm, putting it back in his pocket, reaching to retrieve it from his pocket, or trying to keep it inside his pocket as he ran. His movements created a substantial risk of death or serious bodily
What we said in Dennings was that what created the risk, at least the risk that the police might deploy force in self-defense, was that they saw him making these gestures at his pocket and they didn't know what he was going to do if that was a gun.
Yes.
And here, it's obvious what he's going to do. He's going to drop the gun on the ground. That is literally all the officers saw him do.
That is at some point, Your Honor. But prior to that, he ran with the gun in his hand, disregarding officers'
That's not what we
commands.
identified as what was the reckless part of the behavior. What we thought was the reckless part was the part where he made gestures that left the police unaware of what he was planning.
But one of those gestures, Your Honor, that the court refers to, I think it's on page 238 or 239, was that he appeared to be holding a gun. Here, there's no dispute. He was holding a gun. That's the gesture. Every moment a defendant is
So
running...
is it your understanding that the district court held that this applies not because he threw the gun down, but because he had a gun in his hand at some point? Because that is not how I read the district court decision.
It's not how I read the district court decision either. The district
Okay.
court held that he pulled it out of his pocket, and the pulling motion was the kind of handling that satisfies Denny.
So that's not what you're defending today. You have a different theory you want us to
No,
adopt.
Your Honor, I think either way, because Dennings tells us that. Dennings actually says, regardless of whether he was manipulating it from his pocket, pulling it out, or holding it, that conduct creates a reckless situation. And it makes sense.
That's the conduct, not the throwing of the firearm.
The throwing of the firearm is in addition to that conduct. The reason I started with that conduct is because I think it places it on all fours with Dennings. He took the additional step of throwing the firearm. And he
So
can...
what happens if he comes out of whatever story, Rob, police tell him to get on the ground, he takes off running, he stops, pulls the gun out, sets it down on the ground, and then takes off again. Under your theory, is that sufficient?
That would be a more difficult case for us, but I think it would be sufficient because I think the act of fleeing at all with the gun in your hand while police are giving you commands to stop and pointing guns at you and disregarding those commands, I think that well meets the threshold of substantial risk. And the fact...
So your argument is that eventually he should stop running while he's still got possession of the gun and get down and never get rid of the gun.
Your Honor, I do think that he should not disregard commands with the gun in his hand.
Your argument is whenever anybody who is armed, committing a crime while armed, does not immediately accede to police authority, that's it.
I think that's often going to be a case, not
That's your
necessarily,
argument now.
if he has the gun in his hand, I think that is often going to be.
When would
the
it
case.
not be the case? And how far, I mean, this guy ran for like half a block, right? We're not talking about a prolonged pursuit. What if, like, he just takes 2 steps and then stops?
Your Honor, I think there is a big difference if he can be fairly said, and this I guess would be a factual question in a given case, whether he was responding to police commands.
Well, I think we've said that the flight part, I can't remember the language, we construe very broadly, like what counts as being fleeing can
Yes.
be like a couple of steps.
Yes, Your Honor.
Okay, and if he's armed, when he takes that couple of steps, you would say, I think your argument today is that's it. You shouldn't have taken those couple of steps.
Ordinarily, yes, Your Honor. I can't understate how serious a situation it creates when you have a gun in your hand.
Yeah, but this is like, obviously, committing a crime with a gun makes the crime and everything about it much riskier, which is why this, Mr. Shivers is sentenced to 7 years under 924C because he committed a crime with a gun. The 7 years is for the added risk of committing a crime with a gun.
Yes, Your Honor.
So aren't we kind of double counting that if we say,
I don't think so, Your Honor. There's several options he could have done. One, he could have put the gun down before he fled, like the defendant in Nukes. He could have kept the gun holstered in a way that wasn't available to his hands. He could have not run, which I understand that the rule says you don't get an enhancement for running, but it's not like, or you don't get a reckless endangerment enhancement just for running, but it's not as though you have a right to flee from police. If you put yourself in a situation where you are armed and in a dangerous state, it's not like we have to make a special accommodation so that you can flee in a way that won't be regarded as reckless. If you have a gun in your hand, you have taken the situation to such a dangerous point where there are many, many ways you can make that situation reckless if you haven't already. And there are a handful of ways that perhaps you can flee in a non-reckless way.
It seems like the argument could be made if that's what the Sentencing Commission was getting at, that they would have simply written this to me to say, fleeing from police while armed is a separate enhancement, and that would cover all these situations.
They could have, Your Honor. I think one of the downsides to that is that
But they
there's...
didn't do that, so it's got to be something different.
Well, I think it's broader, Your Honor, because you can recklessly endanger during flight without being armed. You can, for example, the example given in Dennings is unarmed person goes into a stranger's house. That's reckless endangerment on the fairly... there's a lot of things that have to line up for someone to, for that to be dangerous to somebody in a non-speculative way, but this court held it was enough. And vehicular flight is very common. There's a lot of ways to endanger somebody that aren't that way. And I appreciate your question, Your Honor, because I want to address it and a point my friend made, which is the language they use. That substantial risk language isn't, I mean, it is a dictionary term, but it is also the exact same formulation that the Supreme Court said is the dominant formulation of recklessness in modern codes and cases. That term is a flexible term that takes into account whether the circumstances of what you're doing. You know, speeding to take somebody to a hospital in an emergency might not be reckless, whereas simply, you know, driving at the normal speed during, for example, inclement weather could be. It depends on the social utility of what you're doing. I realize that's a term that cases don't ordinarily use, but they do reflect that. MOOCs reflects that when they held that, well, you can't ask somebody to not drop a gun when the police ask you to drop a gun. That's a different story than if you throw it on the ground on your own initiative, because it's appropriate to respond.
It seems like the difficulty here is that we have a very limited record, not on the underlying offenses, but on the enhancement, because we don't know what the description of throwing a firearm, did he throw it 2 feet or 20 feet? Was there anyone around? Did he throw it into the movie crowd as they're departing the theater that night? We don't have any evidence about the susceptibility of the firearm to discharge. So there's a lot of evidence that could have come in, but we have to go based on what's in the record. And the fact that we don't have this additional evidence makes it a much more difficult decision.
Oh, I agree with that, Your Honor. There are scenarios, plenty of them, that would make the case easier one way or another. I would emphasize that the throwing of the firearm was in addition to conduct that, if it is not on all fours with Dennings, which is how I read it, but if it's not, it's very close. And it incrementally certainly
I don't
increased.
understand. I mean, we had held in that unpublished opinion that fleeing with a gun is not enough. And then in Dennings, we said specifically, we don't have any need to reconsider that here. So how is your argument that fleeing with a gun is per se enough for this enhancement consistent with Dennings?
So
And
Jeff-
it specifically said, we're not reconsidering our prior law, saying it's not enough.
The Jefferson decision on which
Jefferson, thank you, yeah.
Dennings relied actually spoke about that specifically, said there's no evidence that the gun was displayed. Certainly we would have a much more difficult case if he had the gun in a holster, nobody ever saw it, and he just took off running, and then police found, oh, he's got a gun. That doesn't really, the running doesn't really create any substantial risk of harm because...
Did you make this argument to the district court? I'm just curious. I do feel like we are so far afield from where the district court was on this. Was this argument made to the district court? Forget the throwing of the gun, Your Honor. You are like barking up the wrong tree. This is about the first couple of seconds where he was, I guess, maybe displaying a gun.
No, Your Honor. Okay. And the reason is because the court found that he had the gun in his jacket and he pulled the gun out during the altercation.
And you think?
The defendant, Mr. Carpenter, disputed that on appeal. Frankly, I think his statement that he had it in his hand makes it more difficult for him.
Right, and I was going to ask Mr. Carpenter, like, aren't you asking us to find that the district court made a clearly erroneous factual finding, and on what basis?
I believe he's asking that, and I don't really think so, because frankly, I think the court gave him the benefit of the doubt. There was no testimony, and there's no statement that says he pulled it out of his jacket or didn't pull it out of his jacket. I think the court believed it was giving him the more favorable decision, the more favorable ruling, when he found that he pulled it out of his jacket and had it in his jacket until he pulled it out to
Just
throw it.
specifically, do you want us to find that the district court was clearly erroneous when it held that he pulled it out of his jacket, or do you want us to find that the district court was giving him the benefit of the doubt? What should we write in our opinion?
I think the answer, I have no objection to this court considering the fact, taking the fact as true that he had it in his hand.
Taking what fact is, I thought the district court said he pulled it out of his jacket.
The district court did say that,
Okay.
and the defense disputes that and says he had it in his hand.
Right, but what if, I think generally we go with the district court and not what
Absolutely.
the defendant says unless we can find it's clearly erroneous. So on what
Absolutely.
basis can we find that that was clearly erroneous?
I don't suggest it is clearly erroneous, Your Honor, and this court can accept that as true. If he pulled it out of his jacket, that created the risk that Dennings noted also as creating a risk that the police would perceive that as...
What was the evidence in the record to show a basis for the district court's finding that he pulled it out of his jacket as opposed to simply holding it in his hand? It could make a finding, but if there's no evidence in the record to back it up, then that would be clearly erroneous, wouldn't it?
It could be, Your Honor. I think it's a reasonable inference and frankly one in his favor. But either way, Dennings specifically says, regardless of whether Dennings was carrying the firearm or reaching to retrieve it from his pocket.
Well, let me go back. Can you cite any evidence in the record that shows the defendant removed the firearm from his clothing?
No, I cannot. And that's why I am very willing to accept the concession that he had it in his hand. I don't think that helps the defense, because if he had it in his hand, he created, for every moment he had that in his hand, a decision point for each one of those officers who had their guns drawn. Do I need to shoot him to keep him from pulling that trigger, intentionally or accidentally? And if he pulled it out of his pocket, he created a decision point for those police officers. Do I need to shoot him to keep that from happening? I want to turn, and that creates a very dangerous situation, Your Honor. And that's what the 3C1.2 is designed to get to. But I want to address the harmless error point because the defendant did get the exact sentence he asked for the reasons he asked for. The district court said the defense brief, which is where the history and characteristics that the defendant relied on, or that the court relied on, are found. The defense brief outlines my reasons for giving this 114-month sentence, which is what the defendant requested if the court didn't apply the enhancement. And then said, and the guideline doesn't have any significant effect on my decision.
Counsel, this is such an unusual case because I totally take your point on the harmless error argument, and I think if the government had not asked the judge to make it express, say explicitly, this is the same amount you would have given, there'd probably be a pretty, very plausible argument for harmless error here. But the problem is the government did ask the judge to, say, call this, say the words so that this will be a harmless error, and the judge wouldn't do it. And so that does make me think that maybe, the judge is reserving the possibility that, and the judge had, discussed, I'm not sure if I'm right about this enhancement or not, and that he absolutely was reserving the possibility that there might be a, probably small, but a small reduction in the sentence if this was wrong.
I think that's a fair point, Your Honor. I will note that this court's decision, Schrader held it explicitly, and Holguin Hernandez and Savian Matute said very specifically, the court doesn't need to say it would impose the
Right,
same
but is there
sentence.
any case where the court is asked to say it, declines to say it, and we still find harmless error?
I have not seen one, Your Honor, because ordinarily what I think the court would do would say one way or another. It'd say, no, I want to reconsider this, or I'm not confident that I would impose the same sentence. Or would say, sure, and that's all we asked for. We didn't ask the court, do this. Would you tell us what the answer would be? And the court declined to say either way. It very specifically didn't go the other way either, and reiterated a point he had emphasized earlier, said, I will say, I don't consider the technical application of this enhancement to be significant. It's difficult to see what he would do on remand, how the court could reach the same result consistently with that analysis, especially when it adopted, it said the defense brief outlines my reasons for my sentence, and the defense brief said a 114-month sentence is no greater than necessary to achieve the purposes of sentencing in the light of my history and characteristics.
Well, we get an awful lot of these, and I don't know that I have ever seen one where the district court judge didn't use language that's fairly uniform now. I don't think I've ever seen one of these where there's an equivocation.
I think the court just declined to answer it. And I can say the same thing, Your Honor. I've not seen this or anything quite like it before either. But I think the court's cases...
Well, if the court declined to answer it, how is that an affirmative expression that, I would have imposed the same sentence regardless of how I evaluated these factors?
It isn't, Your Honor, but under Schrader and under Salvian Matute, that's not required. All this court needs is a fair assurance based on the total record that he would have imposed the same sentence. And here we have a lot of evidence of that.
Well,
We
in
have the
those
sentence he asked for.
cases, didn't the district court say, yeah, I would have posed the same sentence?
Not in Schrader, Your Honor. In Schrader, the court did not do that, and the court looked at the factors, looked at the court's explanation in its totality, and concluded that with fair assurance, it could say with confidence that the sentence would have been the same. And I think those factors, the court's language about the guideline, the fact that he gave the sentence the defendant asked for, and the fact that he incorporated the defendant's reasoning into its own analysis, provides that fair assurance here. See, my time is almost up. I'm happy to answer any questions this court may have.
Thank you very much, Mr. Enright. Mr. Carpenter.
Thank you, Your Honor.
You've got some rebuttal time.
Thank you, Your Honor. Let's start briefly with the final point there about harmless error. And I think, Judge Agee, you've pinpointed the most important point, which is that the presence of the equivocation means that the government can't satisfy its burden of showing, as it says with fair assurance, that the record as a whole, because that equivocation is part of the record as a whole. And I think it relates, as Judge Harris, I think you pointed out, to the fact that this district court judge had said, I'm not quite sure I'm right on this. You should take this to the Fourth Circuit and get clarity. And then he reserves the possibility that maybe if he was wrong, he'll give a lower sentence. That defeats the harmless error argument that the government has made here. And I think, Judge Harris, your point that there is simply no case out there where the judge has declined the invitation and this court has nonetheless found harmless error. The second point I want to go to
says that the Schrader case is close to this in terms of language. What do you say?
I don't think so. I think Schrader and the other cases that my friend cited simply stand for the magic words proposition, and we don't dispute that. There aren't magic words that you have to say, but what's different about this case is that the court specifically declined to say the magic words. I mean, we all know there are magic words you can say. Every district court judge knows there are magic words he or she can say that render guidelines errors harmless. This district court specifically declined to say them, and that, under this court's precedent, means it's not harmless. The second point I wanted to go to was, Judge Harris, your question about clear error, and I think, Judge Agee, again, you answered that there simply is no evidence in the record about him pulling a firearm out of his pocket. It's just not present. And when there is no evidence to support it, that is, by definition, clear error.
So does that mean that he was, in fact, displaying the gun for the beginning of the flight?
No, it means we don't know. And it's the government's burden to prove it. So if what he did in the few steps is relevant to this enhancement, it's the government's burden to prove it. Was he displaying it? Was he pulling it out? If that's relevant, the government has to prove it. They didn't here. All they alleged was that that the officer saw him discard it. I would also quickly take issue with the idea that the judge was doing anything in his favor here. If he had found that he pulled the firearm out, that puts this case on all four with Dennings, and the enhancement applies. So it's certainly the idea that pulling it out, a finding about him pulling it out was helpful in some way, is not correct. I would say there is no evidence that he displayed it. There is no evidence that he pulled it out. There is no evidence either way. And the absence of evidence goes against the government here. The final thing I would mention just briefly for clarity, because I don't think it really much matters, but I do think it's worth highlighting, is my friend began by citing Joint Appendix page 160 and the recitation of the facts there. As he noted, that was the probation officer's assessment of the evidence. That wasn't the evidence itself. It was included in an addendum in response to our objection. The government, if it thought that anything in that probation officer's assessment was relevant, the government had the opportunity at a hearing to put on additional evidence. If you look at the rules of Criminal Procedure Rule 32, G specifically mentions addendums to the pre-sentence report. They're not part of the pre-sentence report itself. The point of an addendum is to highlight unresolved issues and allow the probation officer to comment on them. That cues it up for the district court under Rule 32I to accept any portions that are undisputed and then to hear evidence on any of the disputed issues. The government here declined to introduce any additional evidence in response to the objection, which means we are left going back to Joint Appendix 142, the sentence or the paragraph, Judge Agee, that you read a few minutes ago. The question is, does that allegation, standing alone, support this enhancement? And for all the reasons that we've discussed, we do not think it does. Put simply, discarding the firearm, the only action that the government alleged was seen here, de-escalates the risk. It decreases the risk to everyone involved in the situation. And for that reason, that single action cannot be enough to support the enhancement. If there are other questions, I'm happy to answer them. Otherwise, I will thank the court for its time.
Thank you very much, Mr. Carpenter. We appreciate the argument of counsel. As you know from prior experience, our normal practice would be to come down and greet you in the well of the court, but we're still COVID limited, so when you're back at a future time when we're not, we'll look forward to shaking hands with you. So with that, we'll ask counsel in our next case, Blue Flame versus Chain Bridge, to change places with you. So we're ready for argument in our Blue Frame Medical LLC versus Chainbridge et al. Case. Mr. Citron.
May it please the court. The district court's core legal holding in this case cannot be safely affirmed. What the district court held is that neither state law nor Section 204 of Regulation J prohibits a bank from knowingly wiring money out of its own customer's account without that customer's authorization, and indeed without any basis in law for debiting the customer's account. That cannot be right. That would open a glaring loophole in the center of federal wire transfer regulations. Now, what I think Chainbridge is hoping is that in a case of first impression, this court would be willing to do violence to those regulations in order to make sure that a plaintiff that it hopes you won't like won't recover. But while most of the things it says about my client are either manifestly untrue or at least hotly disputed, the truth is it doesn't matter. The damage will have been done because Chainbridge offers no plausible legal basis for distinguishing this case from the next one in which a bank decides on its own initiative that its customers' money belongs elsewhere. And if the court has any questions about that, I'd really like to answer them and talk through them, because I think the stakes of this issue are really, really high for federal banking law. But if the court doesn't have questions about that, what I'd really like to talk about is the court's second holding, which is that we don't have any damages at all. Or
Well,
quote,
I guess I'll bite. I have a question on your big concern. I mean, it does strike me that part of the answer probably lies in preemption, and that the remedy that you were looking for would come under state law. And what's weird about this case is that the preemption holding is a little bit underdeveloped. And I think one of the reasons it's underdeveloped is because it kind of looks like Blue Flame's trial lawyer got up at that hearing and was kind of like, we're on the same page as you. Everybody sort of agrees. Most of these claims are preempted, but not tortious interference and not defamation. And the district court even says, I agree with you. Those are the ones that are not preempted. And then that's that. And I'm not saying it was conceded, but the way the hearing went, there was no occasion to really talk much about preemption because everybody seemed to be more or less on the same page. And it just strikes me that the answer to your concern, where a bank literally just wires the money out of, let's say, my account, puts it in the bank president's account instead, is I'm probably going to have a state law cause of action. That's no longer about sort of the wire transfer process, the process by which one bank wires money to another at the request of the originating institution. That's what's covered by Regulation J. But I think under our cases like Wachovia, we would just say, well, that's just a conversion action, have at it under state law.
well, I do agree that there is a conversion claim or potentially a fraud claim insofar as, Chainbridge Bank purported to draw up its own payment order, naming us as the originator. That is a false record. We didn't originate it. They know we didn't originate it. In fact, they now say that we didn't originate it. And it is possible that the better formulation of the claim sounds in state law, but I do think this is actually covered quite squarely by Regulation J. I think what the bank purported to do, if you look at page 22 of our opening brief, is that Chainbridge purported to accept a payment order issued in our name as sender, because it says that we're the originator of the original payment order. And the way that you would...
This is the payment that goes back to J.P. Morgan you're talking about?
That's right. We're talking about the return payment out of our account, which was not authorized, conceitedly. And what I think that record is evidence of both the acceptance of a payment order issued in our name and the execution of the second payment order. There's two payment orders in every transfer. There's a my order, if I'm the originator, there's my order to my bank to pay the money on, and then that bank issues its own payment order telling the beneficiary's bank to pay the beneficiary. But that outgoing payment order record is going to look the same as to acceptance of the first payment order and issuance of the second payment order.
Which one do you say is the outgoing payment order?
So it's confusing because there are technically four payment orders. There are two for the one that went from California to us, and then there's two for the one that came out of our account and went to California. What I'm saying is the record at Chainbridge Bank of this transaction is going to be the same for the two payment orders involved, because it's going to show us as the originator and California as the beneficiary on both of them. And that's how they would record that they received a payment
So
order.
why does that make a difference?
They contest that I guess their theory is that they didn't even purport to accept a payment order issued in our name as sender, that they did something worse, which was just wire money out of our account without any basis in law whatsoever, and that's not covered by the regulation, I guess because it's extra bad or something like that. But I think the regulation actually does squarely cover that, because what they are doing when they send money out of our account, when they purport to debit our account, is they are purporting to accept a payment order issued in our name. And the regulation is just unambiguously clear about what happens when you do that and the payment wasn't authorized. You have to return the money to us and pay daily interest. And I just want to cover off what I think is one possible concern, which is that this is going to result in a $450 million windfall to my client or something like that. That's not going to happen. The regulation says that whoever is stuck with indemnification, in this case, it's not clear yet. JPM is appealing the indemnification holding and also suing California for indemnification. Whoever is stuck with the indemnification is going to have a claim against us.
Well, did you ask for the 470-some million back
Yes, we did.
in your complaint?
Yes, it is in our complaint unambiguously with respect to Section 204A. There's a dispute about whether we asked about it for Section 404A. That's our separate claim.
You think in your complaint you did ask for that under 404A? I didn't actually realize that was disputed.
I think if you look at page 90, I'll grab it. I think it's JA 40, paragraphs 92 and 99. We say that there was an obligation to pay the money under Section 404A, and that the consequential damages are among the
I thought you
harms that we
asked for
suffered.
okay.
Yeah. So we say the consequential damages are among the harms, but we don't say we're limiting our claim to the consequential damages.
Okay.
I think it's not, we didn't do a great job. All right.
Can you just,
And part of that is because the damages are overlapping. I just want to make sure I get to,
Counsel, hold on a second. Judge Grigsby has a question.
I'm sorry.
can you just explain procedurally your understanding of where the case was at the time of the decision, particularly on your issue about consequential damages? Read your papers to suggest there are a number of factual issues you feel are in dispute about whether or not there were damages in this case. Also hearing you now suggesting some differences in views about the facts on your other argument. Procedurally, where was the case? What was the information or evidence before the court in deciding particularly the issue of damages?
Sure, I think there's a lot of hotly disputed evidence about the extent of our damages before the court. And that's particularly true with respect to the first 6 million masks, which were going to come from a supplier in New Jersey called Suchi. As to that evidence, really the record is quite one-sided in our favor. All the testimony about those masks and our ability to deliver them says that they were available for shipping out the very next day, that they were in Suchi's live inventory. And the other side really has no evidence whatsoever with respect to those masks. So, it's damages, and we're talking about a hypothetical world that doesn't exist because of the misconduct alleged. So it's the kind of thing that's difficult. No side is going to have direct evidence of an alternative universe, but this is what we count on juries for. We have lots of reasons to suspect that had they not done the wrong thing, we would have gotten a chance to perform and we would have made our profit margin in this case. And also, we would have been able to make our profit margin on other transactions if our reputation and access to capital hadn't been destroyed. They have a contrary story. This is exactly what a jury trial is for. And we have testimony, they clearly believe that our witnesses are not credible. But a credibility determination is exactly why plaintiffs have a constitutional access to a jury. And so I think it's pretty unfair to deny that we have any damages whatsoever.
So what's your best evidence that California would not have canceled the contract as it did?
Well, so there's a couple of different things. One thing I would point the court to is Michael Wong's personal notes. He's a California procurement officer. These are at JA 2892 to 2894. And one of the things he says on March 27th, which is a day after all of this, is, he asks, what should I do? Because we still have a contract with the vendor. So the suggestion that California was going to cancel on the 26th is actually belied by what did in fact happen. But also there's a bunch of evidence in the record that where California witnesses who are adverse to us. Remember, California is on the hook for this if JPM wins its suit. California's witnesses are saying, look, if they had delivered the masks, we would have taken delivery of them. That's at 3012, I believe. One of the California procurement officers said, if they had delivered the masks that were promised, we would have taken delivery of them. Elsewhere in the record, it's at 1602, I believe, they say, look, we just wanted the masks as quickly as possible to, quote, save as many lives as possible. That's utterly inconsistent with the proposition that if we had shown up with 6 million masks using the money that we were supposed to have access to, that California would have said, nah, we don't want them, we don't trust you.
Well, but I understand sort of the difficulties of kind of figuring out a hypothetical world, but if I'm just remembering the facts right, this all goes down maybe on March 26th or something like that, the money gets wired back. And then there are further negotiations with California. It seems like if California was interested in going forward, they could have gone forward. They could have said, all right, we'll give you back some of the money, give us some of the masks. And they didn't do that. They called the FBI. Like, it just seems as though California, for whatever reason, really did not want to go forward with this.
I think what we're going to end up debating, not to cut to the chase, is the proper inferences to be drawn from these pieces of evidence, because we view them very differently. In our view, California cancels because it is lied to about whether or not the money had already been credited to our account. There's evident surprise from officials in California that the wire transfer, when Chainbridge tells them this wire transfer has not been completed, that's actually true and that they're still in a position to take the money back. And we think if we had had possession of the money, it was in our account, we would have ended up talking to California, which is what we needed to do about what would happen next. And we could have showed them that Suchi had the masks and was ready to deliver. I mean, there's a lot of aspersions cast on us in the briefing, but if you actually read the exchanges with California, Mr. Thomas is really upfront. He says, I will show you the text messages with my supplier in China if you want to see them. We need to get prepayment because everyone is asking for prepayment. And I'm sure he would have offered to connect them directly to Suchi. But we are talking about a hypothetical universe that is undermined.
I hear what you're saying, but there's right, and I know you're not saying this, but there is a perilously fine line between what you are saying and, look, if we'd still had the money in our account, maybe California didn't want to deal with us anymore, but we would have had a whole lot of leverage, and we could have probably, we would have been in a way better bargaining position for kind of cramming a bad deal down California's throat. If possession is 9/10 of the law, it would have cost them a lot of money to come get it. That obviously can't, I think that's not what you're saying, and that can't be a theory of damages, right? So tell me, give me the dividing line. You understand my concern.
Yes, what we wanted was an opportunity to perform on the contract. And we had 6 million masks. This evidence is not disputed. All the evidence is in our favor. That the first 6 million masks, they were in New Jersey, from a supplier in New Jersey. They didn't have to come from China. That they were in their live inventory, and that they were ready to be shipped the next day. And we have a signed purchase order with that company, Suchi. That's at JA 1767 and 68.
So
and
can
it's
we-
countersigned.
can
They've
we
agreed to deliver.
summarize- Can we summarize this, because we've let you go over somewhat here?
I'm sorry.
So is it correct to say your best argument here is there's a disputed issue of fact on whether California would have let us perform if we had the money and would have sent them the 6 million masks? Is that your best argument, that there's a factual dispute here?
That's more or less exactly right. If Chainbridge Bank had not scuttled the contract, if we had had the money and were able to wire it out to our supplier, which is what the plan was, we would have performed on those 6 million masks. And I think at that point, everything would have been different because California
Thank
would
you
have
very
seen.
much.
I'm sorry,
Yeah,
I'm sorry, just
sure,
one quick
go ahead.
follow-up question. If that's the argument, if it's about the 6 million masks, I mean, your colleagues on the other side say this was not squarely really raised in the district court, the kind of partial performance argument. And I did look through the record and I see it in like the last sentence in a footnote on the last page of the, I think it's your reply in support of your motion for partial summary judgment. But boy, if there was ever a passing shot, that kind of looks like it. What's your response to that?
I think actually if you read all 3 pages from page 18 to 20 of that filing, you will see a developed argument that we have, that the dispute is about the amount of our damages and that they don't actually have the ability to show that we have no damages at all. And in any event, the district court knows that it needs to find the legal element of
Thank you
no
very
damages
much,
whatsoever.
Counsel. We've been very liberal on the time, so you've got some rebuttal, and we'll now hear from Mr. Schoenfeld.
Thanks very much, Your Honor. Alan Schoenfeld for J.P. Morgan Chase. Judgment should have been entered for J.P. Morgan on Chainbridge's indemnification claim because Chainbridge, not J.P. Morgan, canceled the wire. Chainbridge made repeated efforts to get the wire off of its books and out of the bank, first with California, then with J.P. Morgan. J.P. Morgan ultimately acquiesced and accommodated that request. That's not remotely the scenario contemplated by Section 211F, and Chainbridge has no right to indemnification under it. The right to indemnification under Article 4A belongs to a receiving bank that agrees to cancellation, quote, by the sender.
But your bank did send a request for the money back.
The bank sent I'm sorry.
Your bank sent a request for the money back to Chainbridge Bank, correct?
Correct. It sent what's called a Fedwire Confirmation Code 1001, which is a request for reversal. It sent that only after the CEO of Chainbridge Bank requested the reversal himself. And so if the transmission that J.P. Morgan Chase sent, that request for reversal, constitutes the cancellation, then so does the request from Chainbridge, which came earlier. Article 4A defines cancellation to be a communication, oral, electronic, or in writing for a particular act to be taken. And so to the extent that the court deems that confirmation, which we view as the effectuation of the accommodation that J.P. Morgan was granting to Chainbridge, the same can be said, and the same is true.
So when you sent your communication to Chainbridge, it could have said simply no indemnity.
It certainly could have. That's a possibility that was available at the time, but as we try to explain in our briefs, the idea that indemnification under 211F was triggered at that point in time, given the course of performance between the parties, I don't think was on anyone's mind at that point. 211F is clear that it applies in a particular set of circumstances, factual circumstances. It's meant to be narrowly construed, as all statutory rights to indemnification are. And the idea that in the circumstances where Chainbridge Bank was repeatedly attempting to get the money off of its books, calling California twice, then calling J.P. Morgan Chase, then explicitly saying, can you send a request for reversal and take this money back? The idea that indemnification
What
would
all
have been
J.P. Morgan had to say was no.
no indemnity or reject the request.
Well, either one.
Well, J.P. Morgan was happy to accommodate the request by Chainbridge. It was happy to send the request for reversal and have the money communicated back to the bank. But to answer your earlier question, Judge Agee, the idea that they would put no indemnity in factual circumstances where I don't think it was in anyone's contemplation at J.P. Morgan Chase or at Chainbridge, as reflected in the 143 call, the idea that it would disclaim something.
What difference does it make in that circumstance? You asked for the money back after you'd sent it, and they sent it to you. Why doesn't that end it?
So the language of 211F, I think, forecloses indemnification under those circumstances. The language refers to only a particular set of circumstances where the receiving bank agrees to cancellation by the sender. Very simply put, the cancellation here was not by the sender. I understand Your Honor's focus on the request for reversal, but again, if you look at the circumstances and the statute requires you to look at the course of performance here, what that request for reversal was doing was accommodating the request by Chainbridge for J.P. Morgan Chase to recall the funds. That was the cancellation. And so, our legal position is that this was not a cancellation by the sender, but instead was a cancellation by Chainbridge Bank, which there is the receiving bank.
The sender here is who?
The sender of the wire is J.P. Morgan Chase. I think everyone agrees that for purposes of the 211F analysis, JP Morgan Chase was the sender, the originator.
So you sent the money and you asked for it back. I'm still not understanding why that's not a cancellation.
I think where I take issue with your description is that
I'm just asking a question.
No, I understand, but I think implicit in what you just said is that we sent it and then we asked for it back. I think that the legally operative cancellation was the oral request by Chainbridge to return the funds to JP Morgan Chase, which sort of flips the 211F paradigm on its head. I understand that, and I concede the record shows, that JP Morgan Chase then, pursuant to its agreement with Chainbridge to honor that cancellation, it then sent the formal Fedwire transmission.
So what's the agreement?
I'm sorry?
What in the record establishes a pre-existing agreement between Chainbridge and JP Morgan that Chainbridge wants the money gone and you agreed to send it to honor their request?
So I think the evidence in the record is the conversations between Chainbridge and the JP Morgan Chase personnel, where Chainbridge says, can you issue a reversal request? JP Morgan Chase first says no, and then 3 minutes later calls back and says, we're prepared to issue the reversal request. What do you need from us? That's the agreement to return the payment order. And that is, that's the agreement. But as we view the facts, that is JP Morgan Chase accommodating a cancellation that was initiated and effectuated by Chainbridge Bank.
That's not exactly, it's not exactly the way the conversation goes, right? It's that they call back and say, we're going to be recalling those funds, okay? We have enough concerns that we feel we need to call those funds back.
Precisely, and I think everything that was said.
That's not precisely what you said.
Well, so I was paraphrasing, I apologize, but I grant everything that you said, that's in the record. The request was from Chainbridge Bank to Rakesh Korpal, or to Tim Coffey, who conveyed it to Rakesh Korpal, who was the decision maker. He then directs Tim Coffey to call back and say, we're willing to grant this request.
It doesn't say we're willing to grant your request. It says we have enough concerns that we are going to call this money back.
Absolutely, and however he characterized it, it was an agreement to Chainbridge's request. It was an accommodation. I think the official commentary section, or paragraph 5, I think it gives some texture to exactly what goes on in these circumstances. In the ordinary course, it's the receiving bank that has risk to its beneficiary, Blue Flame here, because the money has gone into the account, or the assumption is that the money has gone into the account. And the question is whether the receiving bank is going to honor a cancellation by the sender, understanding that it faces the risk, reputational, the risk with its customer, and the risk of liability. There's no need for that here when Chainbridge wants the money and is actively pursuing getting the money off of its books and returning it to JP Morgan Chase. There's no reason for there to be indemnification because it is bearing the risk, knowingly bearing the risk, of returning the money to the sender.
And it seemed as though the point of this provision was just like, let's have a bright line rule. We don't care how the parties got to the point where JP Morgan was requesting the money and Chainbridge was giving it to them per your request. Like, we don't care what got us to that point, but now we have the request and we have Chainbridge acceding to the request, returning the funds per your request. That's what we need to know. We're done.
Yeah, respectfully.
Why is that not the right reading?
I disagree, and so I think there's textual evidence that that's not the case. The first is, unless otherwise provided in agreement of the parties, which requires some contemplation of what the parties actually agree to, and Article 4A is clear that that agreement is distinct from a contract, so you always need to look at the course of performance, the course of conduct, what was the benefit of the bargain in fact, is the language of Article 4A. It then otherwise provides if you agree to cancellation. And again, the use of agreement there contemplates that there are going to be factual circumstances where the court needs to inquire as to exactly, as you said, how you got there. And this is one of those rare cases where the court needs to do it. In the mine run of cases, there's not going to be a dispute about these facts. There's going to be...
I don't know. I guess I don't understand your agree argument, your textual argument about the word agree, because even on your account, there was an agreement here, right? Like, there was an agreement.
There was, and there was an agreement, but the question is whether the cancellation...
More than one person can agree.
So there was an agreement. The other textual sort of piece of this is a cancellation by the sender. And I think that's where, we differ with Chainbridge, which is the cancellation here was not by the sender, but instead the cancellation was by the receiving bank. And in those circumstances, on the face of 211F And as confirmed by the commentary, which again, commentary isn't like legislative history. It's not just sort of people weighing in with general views about these things. It's meant to be given some deference, as the Supreme Court said in Ford versus Milholland, because this is the expert, explicative analysis of how this is supposed to play out in particular factual circumstances.
So how about the Second Circuit case, Banca Commerciale Italiano? That seems to take a pretty ritualistic, if you want to use that word, view of the indemnification provision that would not appear to support your client's argument. What do you think?
I disagree. The issue in Banca Commerciale is whether under New York state law you imply a 3-year statute of limitations or a 6-year statute of limitations. And the question is the cause of action, which there was 211F, you're suing under, one that's created by statute. And what the Second Circuit says is this is created by statute. This is an automatic right to indemnification where the requirements of 211F, cancellation by the sender, are met. And it differentiates it from common law causes of action for fraud or unjust enrichment. I don't think we have any dispute with Chambridge about any of that. And the only reason that I think Chambridge invokes Banca Commerciale is to say, well, you should reject the sort of common law construct of indemnification and any suggestion that common law indemnification law matters here because the Second Circuit said that this was a creation of statute for purposes of whether the 3-year statute of limitations applies. I have no disagreement with anything the Second Circuit said in that case. I just think it's beside the point. We don't dispute that absent this statute, this right to indemnification wouldn't exist, and we don't dispute that when the requirements of 211F are met,
Thank you, Mr. Schoenfeld.
indemnification is automatic.
We've let you
Thank you,
go
Your Honor.
over quite a bit too, so you've got some rebuttal time, and we'll now hear from Mr. Orsek.
Thank you, Your Honor. May it please the court, I'm Gary Orsek for the Chainbridge defendants and appellees. I'd like to address Mr. Citron's arguments first, and then I will turn to Mr. Schoenfeld's arguments. There are 3 sets of claims that the plaintiff Blue Flame brought here, and it's helpful to distinguish them because I think they've been blurred a bit. The lead argument appellant presents is the claim under Section 204A, which applies, and I'm quoting here, where a receiving bank accepts a payment order issued in the name of its customer as sender. So the cases that were before the district court, the only ones we're aware of, address the specific circumstance where a bank, such as Chainbridge, receives a payment order that purports to come from the customer, but really doesn't come from the customer. Everyone's familiar with that species of fraud. And 204A draws a pretty bright line rule that if the bank, without doing proper due diligence, sends out the customer's money in that circumstance, it is liable for the amount of the wire. And that's what was pled by the plaintiff here. And that's why the district court quite specifically held that the Section 204A claim fails because Chainbridge did not accept a payment order from anyone, let alone a payment order issued in the name of the customer as the sender. Instead, as the complaint alleges, Chainbridge sent out the money in response to this non-value request for reversal from JP Morgan, which everyone agrees is not a payment order. It's also why Blue Flame's trial counsel conceded at the motion to dismiss stage, and again I'm quoting, that if discovery establishes that defendants accomplished their unauthorized return of the funds by accepting a cancellation request made by California's bank, Blue Flame agrees that this count would not survive upon a motion for summary judgment.
So is that, by quoting that particular wording, that's your basis to say that under 204A, a cancellation process cannot by definition be a payment order under 204A?
That's right, and that is a non-disputed point. I can point you to Joint Appendix page 1288, which pursuant to the Federal Reserve Bank's Operating Circular 6, defines a cancellation request as not a payment order.
So is it your view that that concession by Blue Flame effectively ends its 204A argument?
I do, but I want to amplify that a bit. I'm not asserting it solely on the basis of the technical doctrine of waiver or forfeiture, although certainly it is that, because that's what counsel said. I also want to make the point that trial counsel for Blue Flame was exactly right. He got the law right. And now on appeal, and at the summary judgment stage, as Judge Brinkema observed, counsel tried to walk back what had been said at the motion to dismiss stage. But the district court held, in its opinion, what trial counsel conceded is, quote, precisely what the evidence in the record shows, which is that no payment order was received, certainly not purporting to be in the name of Blue Flame as sender.
Counsel, can I give you a chance to respond, I guess, to the question your colleague started with? If that's right, that what happened here or something like this can't be covered by 204A, and if, as everyone is assuming, I guess you can only get consequential damages under 404A, like, what is the remedy if instead of sending the money back to JP Morgan here, they had just taken all the money out by wire and put it in the bank president's account?
I'm glad you got to that, Your Honor. First of all, what we asserted as preemption and what the district court found as preemption was Section 404A, not Section 204. So the premise in their brief that if 204 doesn't apply, then how could it possibly preempt state law causes of action? They're right, but it's a fake premise. There are all manner of provisions in the UCC that don't apply on these facts and that therefore are not preemptive of state law. To your question, if Chainbridge Bank or any other bank just invaded its customer's bank account and sent the money off to a Swiss bank account somewhere, that's not covered under Article 4A of the UCC.
Even if they do it by wire, it's still not covered.
It's still not covered. What is covered by 404A and what we asserted as preemptive, and the district court agreed, is that if a bank receives a wire and it accepts the wire, which happens automatically under the UCC, and then upon demand of the customer it fails to pay it over, why then the plaintiff has a cause of action, as this plaintiff did under 404A. Judge Brinkema did not say they didn't have a cause of action under 404A. The court just concluded that they didn't prove damages, quote, resulting from Chainbridge's breach.
But that's your position, right, that you can only get consequential damages for the 404A? How are they supposed to get their money back?
They're not. They don't get the money back. I mean, this is not unusual.
I'm sorry, even on our hypothetical, the bank just wires the money to a Swiss bank account. They don't get their money back? All they can get is consequential damages under 404A?
No, my point,
Okay.
I'm sorry if I was unclear.
I'm just asking, how do they get their money back? What's their cause of action for I want my money back from that Swiss bank account?
If 404A doesn't apply because the money did not come into Chainbridge Bank from a wire. So, Your Honor, if you have a bank account and your bank decides to send your money or wire it out, you may have a conversion claim.
A state law claim.
A state law claim.
Okay.
You would have a state law claim. The reason they don't have a state law claim here is because it is preempted by 404. 404 speaks directly to this. They had a live 404A claim. And by the way, 404A says that upon appropriate proof, they are entitled to damages resulting from the breach of 404A. It mentions consequential damages as well, but it uses tort law language of damages resulting from.
So you think that you could get your money back under 404?
You could
Just
if
they didn't
you
ask for it.
No, that's not right.
Okay.
They didn't. They forswore it, as a matter of fact. But there may well be circumstances where the amount of the wire is damages resulting from the breach under 404A. For example, suppose Blue Flame had delivered 100 million masks already to California, and then Chainbridge received the wired funds and didn't pay it over to them, and they had a 404A claim. I suspect they could have adduced proof that those are damages, the full amount of the wire are damages resulting from the failure to pay, because they would have to pay their suppliers, they would have lost profits. In this instance, as I will get to if I have the time, there is no evidence of any of those of types of damages.
Mr. Orsic, on that point, on the damages, again, as I asked your opposing counsel, procedurally, you were in summary judgment. What was the evidence in front of the district court about the damages, and why do you believe there were no material facts in dispute regarding those damages to conclude zero?
Thank you, Your Honor. Yes, that goes to the 404A claim, which is count one. I was going to get to it next, but since you asked, I'll get to it now. The district court cited what it called two equally compelling and independent reasons why Blue Flame failed to adduce any evidence of damages, and Judge Agee alluded to some of these in the questioning. The first is California made excruciatingly clear, as soon as it learned that the principals of Blue Flame had never been in the medical supply business, were political operatives, and had opened a bank account at Chainbridge 2 days before, that it did not wish to go forward. And I'll just cite you a couple of the sites that the district court relied on. First, the deposition of Mr. Corpal, who was the head of fraud prevention at JP Morgan, testified that the recall of the funds by JP Morgan corresponded with a 2 p.m. request from the California State Treasurer, this is on March 26th, that JP Morgan recall the funds because the California Treasurer's office was not comfortable with the due diligence that had been performed. And that same day—
Who's saying that?
That is Mr. Corpal, K-O-R-P-A-L, of
He's the
JP Morgan.
Morgan guy.
Yes. But there's evidence directly from California as well. Mr. Sturmfels from the Department of General Services said that same day, quote, "After further discussion, we won't be moving forward with this vendor." That's in the joint appendix at page 3078.
And that was on the 26th as well?
That was on the 26th. And then immediately thereafter, this is more circumstantial evidence, but it all goes in the same direction. There are repeated expressions of thanks and gratitude by California to JP Morgan for helping to reverse this transaction. I can cite you to JA 1374 in particular, and also JA 1371, where California said, "The state is extremely grateful for JP Morgan's leadership and the steps we took to get this money recovered." So, in other words, we don't have to imagine and guess what a counterfactual might look like, which is Mr. Citron's argument. It should be up to the jury to decide the counterfactual. We have the factual here. California learned the truth about this plaintiff business and immediately and emphatically declined to go forward. The second piece of evidence, Judge Grigsby, that the district court cited is that Blue Flame was tenacious, and they, after the fact, sought to reinvigorate this transaction and sought to entice California to go forward. After all, California could have rewired the money. Blue Flame by then had a new relationship, they said, with Bank of America. But California declined to do it. As the district court wrote in its opinion, John Thomas's March 27th efforts to revive the deal by reaching out to Controller Yee were met with no interest, and with Yee telling Thomas that his company now had a, quote, credibility issue they would need to resolve. Joint Appendix 3048. Blue Flame then reached out to the Department of General Services separately, and as Your Honor alluded to, those communications were forwarded to the FBI. So there's, and I should add that it is undisputed that under the terms and conditions that were incorporated into the transactional documents with Blue Flame, California, as most states would do, had an unfettered right to terminate the contract for any ground that it sought as necessary.
So Blue Flame, as I understand the argument in the colloquy, says that it's undisputed it had 6 million masks in New Jersey. And all it needed was the money from the bank account, and they would have shipped the 6 million, and that creates an issue of disputed fact as to whether California would have gone through with the rest of the contract or at least establishes partial damages.
I understood their argument the same as you did. The problem is, what the district court found is that there's undisputed evidence going in the opposite direction. The court addressed this very point. The court acknowledged that Blue Flame had issued purchase orders to Suchi and this other company, Great Health Companion, but there's no evidence that the orders would have been or could have been filled by the suppliers at JA 3085. And she explained the rationale for that. First, the court held neither the purchase orders nor the reseller agreements included any delivery schedule suggesting that the product would arrive in time to satisfy the representations that Blue Flame made to California. There's no record evidence whatsoever that Suchi or this other company, which were just brokers, by the way, they were not manufacturers of masks, there's no evidence that they had any supply agreements with manufacturers. And I think most important to the district court, and I think which puts the nail in the coffin of this argument, is that neither of these putative suppliers, Suchi or Great Health, ever produced a single mask to anyone, ever. So, as I think you know from the record, Blue Flame was required to respond to congressional investigators after the fact, which posed questions to Blue Flame to list all of the contracts it had entered into with states and municipalities, and then to state what came of those contracts. And of 24 for PPE generally, and 13, I believe it was, for N95 masks, all contemporaneous with this transaction, Blue Flame failed to produce masks to any of them except for these two very small ones that were filled significantly later. And I would note in this regard that as to one of them, Riverside University Health System, that was one of the would-be purchasers, Blue Flame wrote, on April 29th, Great Health informed Blue Flame Medical that it could not deliver the N95 masks because of the actions of the Chinese government. That's at JA 1124. Nothing was ever said under an obligation to tell the truth to Congress to try to lay this at the doorstep of Chainbridge or this transaction. So the best evidence that the district court cited as to, I'm putting it incorrectly. Let me state it otherwise. There is no evidence in the record which would have been Blue Flame's burden to come forward with in the face of our summary judgment motion. There is no evidence in the record that any of these putative suppliers could have produced any masks because neither of them ever did produce any masks. If I may, I wanted to, and I know we're jumping around a bit necessarily, I wanted to respond briefly to Mr. Citron's, I think, convoluted argument as to why Section 204 applies here, because his argument is that the entire amount of the wire must be paid over as damages if 204A applies. As I explained, Chainbridge Bank never accepted any payment order, let alone one purporting to come from the customer as sender. The response to that counsel urges is that Chainbridge Bank must have accepted, quote unquote, under the language of 204, the very order that it sent to Blue Flame to return the money. And for that proposition, they cite Section 209A, which says that a bank, quote, accepts a payment order when it executes the order. So in relying on that language, their argument is, By definition, you accepted a payment order because you issued a payment order. That is as wrong as it sounds, and it ignores Section 301A, which defines execution, and it says this.
Can you go back? I'm having trouble following that. Can you go back to accepted a payment order from whom?
Right. You're right to be confused. Chainbridge never accepted, let me put it more simply, it never received any payment order from anyone. Everyone concedes that. What Mr. Citron says is, as a matter of law, that can't be right, because under the UCC, there have to be 2 payment orders, and when Chainbridge
Is that because the cancellation order, if that's what it was from J.P. Morgan, cannot be a payment order under 204A?
It's true that the cancellation order cannot be a payment order, but the rest of this argument, the premise of it, is completely false. It is not true that every Fedwire transaction comprises 2 payment orders. To the contrary, the UCC at Section 4A 102 in the comment says a funds transfer is made by means of one or more payment orders. And there was only one payment order in returning the funds here, and that was the one by which Chainbridge Bank issued the money back to J.P. Morgan. There was no first payment order at all. And so this legalistic but incorrect argument, citing 209A, is that by issuing the payment order, Chainbridge Bank magically must have accepted the very same payment order that it issued to J.P. Morgan. Section 301A and the comment, which is even clearer, forecloses it. It says, the comment says, execution refers to the act of the receiving bank in issuing a payment order intended to carry out the payment order that the bank received. So in other words, if Chainbridge had received a payment order and then issued a new payment order in response to the one it received, by issuing that second payment order, it would have accepted the first payment order. That's what 301 says, which they don't mention. And again, I've already addressed this. They say, well, there must be 2 payment orders because the UCC says there must be 2 payment orders, but what they cite is one of those cases that are listed as examples in the commentary, and they pick a case in which there were 2 payment orders. But as we know from Section 211, which addresses the cancellation of a wire, there are transactions like this one all the time that consist of only 1 payment order. You get a non-payment order in from the bank requesting cancellation. Everybody agrees that's not a payment order. And then you issue a payment order. That's 1 payment order, and that's what happened here. The 204A claim, as fashioned by counsel on appeal, I regard as not colorable whatsoever. I've addressed 404, the district court's grounds were that there is no jury submissible evidence of resulting damages. There was a question posed about partial performance. That was raised even later than Your Honor remembered. It was raised for the first time in a footnote in a reply brief after summary judgment argument, after summary judgment was closed, in support of Blue Flame's post-summary judgment motion to allow the court to consider Mr. Huang's declaration, which the district court rejected, both because it was procedurally improper and because it was not helpful. There's been no, so the partial performance doctrine was waived, but in any event, Judge Brinkham's opinion that there's no evidence that any masks could have been produced, because indeed none were produced, I think disposes of the partial performance argument, even on the merits. Another argument that was never raised until now on appeal is that under the 404A claim, under 404A, the plaintiff is entitled to recover the full amount of the wire. That's another one that was not only waived by inaction, but was affirmatively disclaimed by counsel below. That's all in our, well, it's not all in our brief, but counsel conceded it at JA 3034, and in any event, the argument is simply wrong, as the comment to 404A says that damages under 404A are addressed in the final sentence of 404A, which limits damages to resulting damages. I see that I'm about out of time, but I want to say one or two more things on Blue Flame's claim.
Counsel, in fairness to you, we let both opposing counsel go over, so we'll give you a couple extra minutes if you want.
Thank you, Your Honor. We argued in the district court, and I urge as alternative grounds for affirmance here, that Blue Flame is not entitled to invoke the remedies, any remedies under the UCC, because it has not complied with the obligation to pursue those remedies in good faith. Judge Brinkema did not reach that ground because she didn't need to, but her opinion, I think, finds the lack of good faith. She held that, and I'm quoting, Blue Flame's apparent initial misrepresentations to California authorities were recognizable. That's at JA 3090. And counsel's only response to this point is to say that because the requirement to act in good faith appears in Article 1, not in Article 4A, it doesn't apply to this case. That's incorrect, and I didn't have a chance to respond to this.
I'm sorry, I thought their argument, and maybe that was one of their arguments, I understood their argument to be more along the lines of sort of the alleged bad faith here was sort of Blue Flame as to California, and that's sort of a separate and distinct set of transactions, and it doesn't relieve Chainbridge. There was no bad faith as between Blue Flame and Chainbridge, so why should Chainbridge get out from under its obligations?
We did cite evidence that there was bad faith as to Chainbridge, which the judge didn't reach. When Mr. Gula opened the bank account, he affirmatively misled Chainbridge about what the account would entail. But more to the point, there's nothing in the bad faith section that says the only disqualifying bad faith is bad faith perpetrated on the bank. If the bad faith would have precluded Blue Flame from recovering as against California, it makes no sense to allow them to pursue the same remedy against Chainbridge. And in any event, the language of this section, 1-304, says every contract or duty within the UCC imposes an obligation of good faith in its performance and enforcement. And so our argument is they are seeking to enforce a right under the UCC as against us in a circumstance where they engaged in bad faith. And even if the bad faith were only as to California, it's the same set of circumstances.
So there's something sort of intuitively appealing. I understand what you're saying, and I'm not making any assumptions about what happened here, but if the allegations are true, it does seem sort of odd to say, you know, you successfully defrauded California, at least for a short time, out of $500 million, and now you want it back because there might have been some technicality in the way the money was wired. But are there any cases, is there any authority for, and maybe this is just sort of an unusual set of circumstances. I tried to find a case that looked like this under the good faith doctrine, and I couldn't quite find one.
I did as well, Your Honor, and on a number of these provisions, there is no case law. Helpfully, the commentary and the text are pretty clear, but I didn't find any either. I'm not going to say anything more about the state law claims other than to try to disabuse the panel of the notion that we or the district court relied on 204A, which was inapplicable, to preempt the state law claims. It was 404A, which the district court found was applicable, that preempted the state law claims. They don't appeal on defamation. On tortious interference, I'm going to stand on our brief. If I may have 90 seconds to address the indemnification.
All right, go ahead. Let's hold it to 90 seconds.
Yes, Your Honor. The main argument that was made here is that as a practical matter, it was Chainbridge that canceled the wire, and so 211F can't apply. First and foremost, a receiving bank cannot cancel a wire. All you have to do is look at Section 211A, which defines it as a communication by the sender. There is no precedent and no sense that one has to look to the events leading up to the cancellation to decide who directed it. There is always an agreement before a return because sections 211C and 211F make very clear that the receiving bank, that's Chainbridge Bank here, upon receiving a cancellation request, can return it or not return it. So anytime it's returned, there must be an agreement, and therefore the argument that if we agreed to do it, we must have wanted to do it and must have done it for our own reasons, and therefore indemnity doesn't apply. That would swallow up the entire rule. The comment says that indemnification is automatic. The Banca case says that it is absolute. And simply as a factual matter, the notion that we directed the cancellation is factually false. 35 minutes after the original wire went from JP Morgan to Chainbridge Bank, Mr. Coffey from JP Morgan called up to report his, quote, concerns of fraud. 13 minutes later, Mr. Corpal called Chainbridge Bank, warning Chainbridge Bank that its global securities investigation was all leading to not good places. And then, as Your Honor pointed out, at 1:37, Mr. Coffey called Chainbridge Bank to say, quote, we're going to be recalling those funds, which you recounted already. And then at 2:05, they sent a formal cancellation request saying, as per remitter's request, please return the funds, quoting our reference. There was no agreement to displace indemnification. That was stipulated in the record, not by conduct, not by anything else. And the notion that our damages, which so far are only attorney's fees, and I hope it remains that way, are not damages or costs resulting from the return of the wire is baseless. The whole premise of the lawsuit by Blue Flame is that we're suing you because you returned our money instead of giving it to us. That resolves the whole matter.
Thank you very much.
Thank you.
So we've got rebuttal, first from Mr. Citron.
So I don't think that I heard a response to the question how we're supposed to get the money back if they wire money out of our account without authorization. And I understand that they are now arguing that they didn't even purport to accept a payment order in our name. Instead, they just sent the money out of our account without any authorization or basis in law to debit it whatsoever. I do think this is best handled under the regulation itself. If you read comment 1 to section 204, it says that the premise is that the bank has to have a legal basis for taking a payment out of our account for the payment order, and it takes the risk of loss if it doesn't have a legal basis. And they do not argue that they had a legal basis for taking money out of our account. You cannot excuse that. I also think there's a couple of unfair things happening here in an effort to sort of bootstrap concessions that would allow them to wriggle out from the legal problems that they're creating. At the time of the motion to dismiss, it's still disputed whether or not the money had actually been credited into our account. And 404 is meant to cover the situation in which it's not credited into our account. And the 204 claim arises when we have the money and they wire it out without authorization. The district court holds at summary judgment, and they no longer dispute that they actually had credited our account. And what they are saying now is that somehow our state law claim for conversion or fraud is preempted with respect to that illegal transaction, wiring money out of our account without any legal basis whatsoever. That cannot be right. As to partial performance, I just want to clarify what was happening in the district court because, again, I think it's really unfair. They moved for summary judgment on you don't have damages at all in addition to other theories. We moved for partial summary judgment on liability under 404A, saying They don't have any defense. And the dispute is about the amount of our damages, not whether we're damaged at all. And in our reply for that portion of the cross motions for summary judgment, we emphasize on page 20, this is a paraphrase because I don't have it in front of me, something like the page 20 of the reply, document 159, to the extent they are disputing the number of masks we were going to deliver in April, that goes to the amount of our damages, not whether we have damages at all. And then the district court knows what it has to hold. It holds there's no damages in any respect because it knows that that's the legal element of our claim. It doesn't think we've waived partial performance or say anything like that. You know, the best they say in their brief is we didn't focus the district court's mind on this issue. I don't think that's fair. This contract was obviously not $100 million or bust. The whole negotiation is that we're going to be delivering it in tranches, and we deserved the opportunity to perform. Judge Agee, you asked whether we asked for this relief. This is our Section 204 claim. The request is on JA 43. It's unambiguous. We asked for the money back, and we are entitled to it. And Judge Grigsby, I think your question is right. You have to focus on the procedural posture and the evidence in front of the district court. My friend points to their evidence and their preferred inferences, but we have our evidence too. And I just want to point to the most important piece. On JA 1557, Mr. Thomas testifies without contradiction that Suchi had 6 million masks in its live inventory that were ready to ship out the next day. There is no evidence on the other side with respect to that proposition. All they can say now is that he didn't offer sua sponte the basis for his personal knowledge of that fact. But they were examining him, and they chose not to ask him any questions about that. It's not his responsibility to be like, oh, by the way, here's how I know that. At trial, they can try to prove that he's not a credible witness. Or we can put on Ms. Suchi, who will just, will testify to the availability of the masks or not. But we're way out ahead of ourselves if we're trying to say that there's no prospect, based on the evidence in the record, that we have any damages whatsoever.
So, counsel, try to bring your argument to a close here.
Yep. One last thing. Judge Harris, you asked, is your argument that if we had had the money, we would have had leverage and we could have extracted something? I just want to point to some evidence in the record that I think is really important. When we couldn't deliver, we have told California throughout this period, if we can't deliver, we're going to refund the money. And when we can't deliver masks to Tennessee as a consequence of what happened here, we don't just refund Tennessee all the money. We also refund them the credit card fee that we're not holding because they incurred it and that was the fair thing to do. Right? There's all these suggestions that we're bad actors, but we weren't going to make a single dollar if we couldn't actually deliver the masks. That's what we wanted to do. We wanted an opportunity to bring together our suppliers with the funds that California had so that we could lock up contested inventory in the middle of a pandemic. This is March 2020, right? There's no certainty. The fact that Suchi or Great Health Companion can't deliver after its big deal falls apart when a bank unexpectedly reverses a wire and illegally reverses a wire isn't surprising, right? Like there is a global scramble to lock up these goods. And what they are saying is there's no way any reasonable jury could hold that you are damaged at all from their involvement. And I think that that is, gratuitously unfair.
Thank you very much for your argument, counsel. And we'll now hear Mr. Schoenfeld in rebuttal.
Thanks, Your Honor. I will make it brief. I just want to make 2 points. The first one is that Chainbridge's argument on cancellation, at least the legal argument, depends on the premise that a receiving bank can't cancel a wire transfer. That's not true. There's nothing in the statute that says that. 211F refers to cancellation by the sender. If it were the case that every cancellation is by the sender, that language would be redundant and it would be surplusage. Section 1105 and 1106 both define the functions of the receiving bank to include cancellation. JA 2940 is a Fedwire manual that describes the manner in which a receiving bank can derive a reversal of a transaction because, as Mr. Orsic mentioned, transactions conducted over Fedwire are automatically accepted. You can only be talking about a cancellation there. It's not a rejection. So there's no evidence on the face of the statute or in the record to support this. The starting premise of their argument that cancellation can never be done by a receiving bank. The second and last point I'll make is Mr. Orsak suggested that it's stipulated in the record that there was no agreement between the parties to provide otherwise, as the prefatory clause of 211F suggests. We point the court in detail in numerous respects the course of performance between the parties, culminating in the 143 internal call between the Chain Bridge personnel about the wire. What was said, what was not said, and then what was confirmed in that call suggest at the very minimum that there's a disputed question of fact as to what the agreement of the parties was, what the benefit of the bargain in fact as to precisely how this transaction would be reversed, and whether indemnification was part of that bargain. And it's for a fact finder to determine whether in fact the parties agreed or provided otherwise through their course of performance. Thank you very much.
All right, thank you. We appreciate the argument of all counsel in this case. And as you probably know, our practice is to come down into the well of the court, greet counsel personally, but COVID still has us restricted in that regard. So we hope you'll return on a future occasion when we're able to do that. So the court will now take a short recess, and Rachel, if you'll come back when we go.
This honorable court will take a brief recess. The Honorable Judges of the United States Court of Appeals for the Fourth Circuit.
All right, please be seated. And we'll take up our next case, ERL versus Adoption Advocacy, Inc. Mr. Butcher.
Thank you, Your Honor. May it please the court? Present today with me is my partner, Deborah Butcher. Watching today are my clients online. First, I want to start with the procedural history because a lot of the opposing counsel's briefs just misstate what was factually in the complaint or what actually happened in this case. When we filed, we didn't know who the adoption workers were. And the original complaint lists an adoption specialist and adoption specialist supervisor. And the allegations, our belief was they worked for DSS. And then afterwards, after we filed, we asked for an ex parte motion to conduct limited discovery under Rule 16, Rule 26. The court granted that and allowed us to send a subpoena for records. And from there, we have our complaint. And that's, although it's not in the records, we sued the people who were the adoption specialists.
I want to make sure I'm on the same page as you here. So you send a subpoena to the South Carolina Department of Social Services, is that right?
Yes, Your Honor.
And say who were the adoption specialists on this case, and they point to two people who work for the adoption agency.
Yes, ma'am. Yes, Your
Okay.
Honor. Yes, and so if you look at docket 7, 8, 9, 10, afterwards, you'll see the filing of the correspondence regarding the subpoena and that type of stuff. So under Rule 12B, when you were looking at all evidence and in the complaint and that type of stuff, you can also take inferences, we believe, from the record regarding who the parties were. And the reason why that's important is in adoption advocacy's defenses for res judicata, they constantly state that the person in court who was making reports regarding the adoption was a state actor. The only person that was making reports under the complaint and who made reports and investigations, if they were a state actor, the only person was adoption advocacy and its employees. So from that perspective, we believe that is an admission. But going on from there, I mean, bottom line, we know that ERL was a minor. She was incompetent. She's a permanent ward of the state of Ohio. She had no ability, no free will to protect herself, to determine where she was going to go. She was entirely dependent on the state of Ohio on her placement. Ohio sold that responsibility to adoption advocacy.
Is that the allegation? I'm not sure it really matters, but I was, for your state action argument, but I was a little bit confused, and it may just be because there hasn't been discovery yet about sort of which way the contractual relationships ran. But the allegation in the complaint is that it's the state of Ohio or the county in Ohio that contracted with the agency, not the state of South Carolina?
That's correct.
Okay.
Even though
I'm not sure it matters. It's a state either way, but okay.
well, the appellees say it was the state of South Carolina, and they could be true because guess what? We don't have a contract.
Discovery.
You know, but within the four corners of our complaint, that's our allegation. And to me, it only made sense because I'm looking at the ICPC, with the interstate agreement on the placement of children.
So did your discovery request go to the motion for summary judgment or the motion to dismiss?
My discovery requests. So you're talking about the motion to conduct an initial discovery. That was immediately after filing the complaint because we filed against two John Does, adoption specialist and adoption specialist supervisor.
Well, I thought one of your arguments was that there was error because there was no discovery allowed.
Right. So we weren't complaining about that discovery because we found out there were no DSS employees and they didn't have any files or records regarding their employees doing anything with the adoption. Our concern was when when the court is supposed to look into a deeper dive into state action, and we don't have a copy of the contract with adoption advocacy. We don't have we don't know anything about what happened between.
But I'm going back to the question of, does it go
Yes,
to
sir.
the motion to dismiss or the motion for summary judgment? Because there would have to be differing legal authority
Correct.
for each one.
So,
And the court granted a motion to dismiss,
yes, sir, and it was
not the summary judgment.
correct. It was only it was framed by the appellees as a motion to dismiss or an alternative for summary judgment. But it was in the initial pleading stage. They never answered, and so we never got past there.
Is there an order of the district court denying you the discovery? I couldn't understand what you were appealing, I'm going to be honest. As to discovery, I totally understand your argument about state action, but what is it you are appealing? It looked to me like, as you say, you wanted this, this very preliminary discovery, the subpoena, which you got. What was
Right.
it? What thing?
Well, the next was to at least send some production for the basic file from adoption advocacy and send a subpoena to Franklin County Children's
And the district court
Services.
denied that?
It denied that, Your Honor.
Okay.
And of course, if this weren't dealing with adoption and foster care, in any other venue, a litigant would be able to get records, but everything is sealed.
Not to belabor this, but what's the authority to get discovery on the motion to dismiss?
The authority, what I would say is that the court should view as to whether or not there are enough facts to be ruled upon. And in a case like this, we have plenty of facts, but what we don't have are extremely dispositive facts of who was doing what to Franklin County and adoption advocacy.
As I understand what the district court did and what you pled,
Yes, sir.
the district court said it was going to grant the motion to dismiss because your allegations do not plausibly allege that defendants are state actors, because foster care is traditionally the exclusive function of the state. So that goes to the question of what are the methods of determining a state actor? And there's, I think, fair to say, some confusion in their cases as to whether the exclusive public function theory is all there is, or whether there's a separate delegation of a constitutional duty theory, which you may have pled on somewhere in your complaint, because I know I saw it.
Yes, sir.
But you didn't plead anything on the exclusive function theory. So you have to be going on the other one.
Yeah, now, as far as I understand, pleading an exclusive function theory isn't necessarily a pleading requirement for 1983. I think isn't that an argument under that you can make regarding 12b-6, or it's not, I don't think it's a required element to get me through the door, even under the heightened pleading requirements that the Supreme Court has created for a lot of these cases. I don't think I have to say, so-and-so violated my civil rights under color of law, and also, they're, I don't think I have to plead that specific theory.
Well, can you maybe just say what is your theory of state action in this case?
My theory of state action is that it is the intertwinement, it is the actual specific delegation of the placement of this child and supervision.
So those are two different things. There's intertwining, I mean, not to get all technical about it, but But one of your arguments, as I understood it, was this delegation theory, this West versus Atkins theory, that, look, if the state has custody of someone and has an affirmative constitutional obligation not to do something like make a placement in deliberate indifference.
Yes, sir.
And you could sue the state for doing that. The state doesn't get out of that by saying, well, instead of doing it ourselves, we hired this person to do it. I mean, I thought that was basically your argument.
Yes, that is basically yes, Your Honor.
I mean, there is also some, I understand you also talk about the regulations, and this is all very tightly regulated, which, probably not enough by itself, but the intertwining.
Right, and I think those regulations are more evidence of, rather than it's not going to create it. And I think the other thing is...
Not to belabor this, but is paragraph 41 of your complaint, which is on JA 17, is that the crux of your state actor argument? Because if there's something else in there, now would be a good time for you to tell us.
At this point, but hopefully during my rebuttal, I can give you better direction on that, Your Honor.
Well, let me ask it this way.
Yes,
Is
sir.
paragraph 41 an allegation in your view that there was a constitutional duty and that duty was allocated, contracted, transferred to the defendant adoption advocacy?
Yes, Your Honor. Yes, Your Honor. And that was the other reason why some at least limited discovery regarding adoption advocacy was, what does Franklin County's contract say when they are sending these kids and having these contractors assume these duties? Does it say you're going to be 100% responsible for any harms, constitutional or unconstitutional, those types of things?
But you would agree, I take it, that for 1983 purposes, that you have to begin by pleading that adoption agency is a state actor.
Yes, Your Honor, and I believe that I pled that in the first cause of action. And I believe that we show through the facts in there that they did all of the actions that a state actor would, such as Debbie Thompson did in the Doe X. Rel. Johnson case, that we rely on as the basis for that, Your Honor.
Well, before your time runs out, why don't we move on and assume that there's an adequate pleading that the defendants are state actors. They say they're entitled to qualified immunity. What's your response to that?
Absolutely not, because they were told on, was it March 5th or March 10th, 2010, by the Fourth Circuit that if you're a provider, if you violate a child's substantive due process rights, then then you're liable under 1983.
Is that the date of the Doe case?
That is the date of the Doe case.
Anything else before you sit down?
No, Your Honor.
If you would just do me a minor favor.
Yes, ma'am.
When you come back for rebuttal, just where in the JA do I find this discovery order by the district court that you're appealing?
I didn't include it in the JA. It's in the,
If you're appealing it, okay.
it's in the,
You can tell us
Yeah,
when you
doesn't
come
matter,
back up.
yeah.
it's in the docket. Yes, Your Honor. Thank you.
All right, Mr. Parker.
Thank you, Your Honor. May it please the court. Chase Parker for Adoption Advocacy, June Bond, and Joe Haynes. And Your Honors, I want to turn to the initial point of the discovery. Like the court mentioned, the discovery order is not in the joint appendix. So I'm not sure procedurally how the court can go and rule on something that's not been entered into the record in terms of how the discovery order affects a pre-pleading ex parte discovery request that did not involve my clients, that was supposedly served to the South Carolina Department of Social Services that would somehow get Franklin County's contract with my clients. I'm unsure of how to handle that. All I know is that the rules explicitly limit pre-suit discovery to preservation situations. And nowhere in the record do we have any sort of evidence showing that this was some sort of vanishing evidence or something that couldn't be brought up post-complaint filing.
Is your argument that irregardless of the factual underpinning, they don't get discovery on the motion to dismiss?
That's correct, Your Honor. All right. And, Your Honor, and if alternatively we go to the summary judgment portion of the motion, all those things are based upon things that were attached to the complaint by the petitioners. So, and I'll get to that at the end, but essentially the basis for the summary judgment motion and for the estoppel arguments is that the adoption decree for these children was attached and essentially laid out the statutory investigations that were done by the court and the findings by clear and convincing evidence by the family court in Beaufort County. So that's what the estoppel argument is based upon, but I think the primary question the court has today is about the state action issues. And the court is correct in that there's a multitude of different formulations of how the court can go and discuss state action, especially when it relates to private contractors that work with the government. You know, we have the nexus test, the public function test, and it's been put out in a factorial number of ways. But I think the court really has two ways to look at it. We have essentially the public function test, which we've discussed, and we briefed before the district court. And the district court found that the care of parentless children, whether they are ward children or relinquished children or consented adopted children, essentially has never been the exclusive prerogative of South Carolina state government.
Well, the district court said that the plaintiff didn't plead that in any event.
Correct.
Is that
correct.
your understanding?
That's my understanding as well, Your Honor, yes. And to go to the complaint, the factual allegations of the complaint are that our clients are private adoption placement agencies that had some form of contract. It's not explicitly said within the complaint that they had some sort of, or they assumed some duty that would forever, endear or inure them to the benefit of the plaintiffs, that they would have to watch them no matter who they were placed with.
I thought the complaint pretty clearly alleged that under Doe, right, the state at least, as to children in its custody who have no other form of protection or no choice about where they're going, owes them a duty not to make a placement in deliberate indifference of a risk to the child's health and safety, and that here, that obligation, the placement obligation, was contracted out to these employees of the adoption agency, and that under the West line of cases, that is enough to make them state actors, at least for purposes of a 1983 action alleging that they violated that duty to make the placement without deliberate indifference.
And I read the allegations the same, Your Honor. And so,
okay, well, why is that wrong? That seems
sure,
pretty straightforward.
The second portion of the test that I wanted to discuss is this delegation or the special relationship doctrine that's espoused in Doe. And so what Doe essentially says is that when the state either does...
If I can get you to consider your answer to this, I don't read the district court's decision as having addressed the delegation of a constitutional duty. Do you agree?
I would agree with that, Your Honor, yes.
So if they've alleged that in paragraph 41 and the district court did not address it, wouldn't we at a minimum have the district court address that specific claim?
Your Honors could remand the case and have it addressed by the district court, but I also believe that the federal rules allow this court to affirm a order that has inured to my client's benefit and under a de novo standard of review make that determination themselves without remanding it back as long as it was brought before the district court.
Right.
Otherwise, we would have to file...
Just here, though, on the complaint, and the complaint has made an allegation that arguably we can assume for purposes of argument that states a proper basis under 1983 for a state actor, the delegation of a constitutional duty. So that was raised. It's before the district court. The district court didn't rule on it. how are we authorized to proceed to rule on that on the merits, particularly in favor of your client, when we're in this posture?
Sure, Your Honor. And the second part that I was going to discuss before for Your Honor's question is a purely legal question that can be contained within the four corners of the complaint, and that's the special relationship doctrine. And when we go and we look at West and Doe XRL versus Johnson, essentially what the court is saying, the Supreme Court and this circuit, is that when there's a custodial relationship, and by that a physical contained custodial relationship with a ward of the state, an institutionalized person, then that duty arises to comply with the 14th Amendment. Here, however, we're talking about a case that this court has actually treated before when we're talking about whether it be Department of Social Services placing a child with a family member who is not the custodial family member, a grandparent, an aunt, or many of those. That's the Milburn case, Wellburn, I believe, as well. But essentially, this court has already ruled that when a person is placed with even a non-custodial family member, they're not in state custody.
Right, and that's why I think this case would be very different if the focus were on the harm, the grievous harm done to this little girl after she was placed with the family. But to the extent the complaint has alleged, the problem is with the placement. That's what puts us, I think, pretty squarely under Doe. I don't really see a way around that.
Sure, Your Honor, and I believe that there is. So when we look through the Child Welfare Act, or Chapter 9 of the South Carolina Code, it's very clear that South Carolina distinguishes between a foster home and a private adoptive placement. So if we go into Doe, I mean, it says explicitly in Doe that the duty to protect a ward child begins because they are placed within a state-sponsored or a state-certified foster home.
Well, that's not what it says. It says that the duty springs from the fact that the child is helpless and in the state's custody. There is no one to protect the child except for the state. That's what gets you out from under DeShaney and triggers the duty. I cannot read that opinion as turning on whether the anticipated placement will be for foster care or adoptive care. It's about the relationship between the helpless child who is in the custody of the state and the state's duty to protect that child.
I understand Your Honor's position, and respectfully, we disagree. We think that it's the analogous to placing with a non-custodial family member, which the court has held time and time again for 40 years, that does not give that 14th Amendment protection.
Well, the claim raised here is a constitutional claim, not a statutory claim. They may have a statutory claim, but as I understand it, they've raised a constitutional claim. So a statutory defense, I'm not sure would be a constitutional defense, would it?
I may not be understanding Your Honor's question. I suppose the statutory defense is because the state custodial relationship comes from physical constrainment of the child. Obviously, the child doesn't have a decision whether she gets placed with a family member or whether she gets placed in kinship care or whether she gets placed in a state foster home. But like I said, Doe uses the specific words, a state-certified foster home. And when we look to the South Carolina regulations, there's a distinct statutory difference between the two. And I think Your Honor is right that there are remedies through, and they may be limited.
Is your position that in terms of a state actor analysis, that foster child placement cannot, as a matter of law, entail a constitutional duty?
No, Your Honor, it's not that foster care cannot, it's that
foster care placement.
Well, there's a distinction between adoptive placement with a private family and placement with a state-sponsored and state-licensed foster home or foster unit. And that's where we get to the custodial distinction is that, like I said, often children who are relinquished or consent, have family members consent to their adoption or placement in foster care, we go in and you see that the duties that the statute in South Carolina give is that when a child is placed within an adoptive family, and it uses that term specifically, adoptive family, not a foster family, when they're placed with an adoptive family, the DSS cannot go and retrieve that child from an adoptive placement without going to a family court and petitioning for a removal back into their custody. So I think the statutory scheme lays out what South Carolina law intends when they have a distinction between foster care and private adoptive placement. And in the complaint, the real factual deficiency in the complaint is that there is no allegation that the Mitchells, the family that were eventually convicted, ever were paid by the state of South Carolina.
They're not saying that the Mitchells were state actors. This is why I'm so perplexed by all of this. We do have cases saying that foster parents are not themselves state actors. But that's not, why would they have to allege anything about the Mitchells? They're not alleging that they're state actors. They are alleging that it was the part where the state placed the child, the placement decision itself, that ran afoul of Doe, and the fact that it was done not by someone who gets their paycheck from the state, but by someone who the state subcontracted out to doesn't make any difference under West.
Understood, Your Honor, and I understand the distinction the court is making, but really the harm occurs after the placement decision is made. And so, I mean, I know it shows the difficulty of line drawing.
That is exactly what Doe is about, because Doe was decided in the face of a bunch of cases saying that harm that occurs after the placement, that may not be state action. So Doe very specifically said, we're talking about something different. These are two separate things. We're talking about the placement decision, and the placement decision itself is governed by the 14th Amendment. Notwithstanding DeShaney, you have a 14th Amendment duty to these kids when you place them. We may not be able to help them after that, but we're focused in on the placement decision itself. That's what we're talking about. And they allege in their complaint that it was the placement decision that caused the harm.
And I understand Your Honor's point, and we disagree and think that the custody and harm occurs after the placement and that there is no custody that nurses Franklin County.
That takes me back to the question I thought I asked earlier. Is it your position that there simply is no constitutional duty in foster placement?
Again, I would draw the distinction between foster and adoptive, but our position is that in a private family that is not licensed by the state of South Carolina, there is no constitutional duty or protections from private harm. And that's something that the Supreme Court has instructed us for.
But what's the private harm? I mean, that's just, I think we all agree there's no constitutional protection from private harm. So can you, without sort of, you understand, like, that's not satisfying to me because you've simply restated the question.
I understand, and I don't mean to be question begging, and I apologize.
No, I know. I'm asking you to be specific.
Sure, and the harm that I'm discussing is the actual abuse allegations, is that the harm and reporting that comes after the placement, anything after that, and after the actual adoption, when the legal connection between any of these states is cut.
But how is any of that relevant here? This is all leading up to that point. The allegation is, which may be insufficient, it may not be factually provable, but the allegation, just for purposes of state actor pleading, is the placement in and of itself entails a constitutional duty, and that duty was delegated to your client. That's all we're doing up to this point, because it's on a motion to dismiss. Why is that insufficient in and of itself? And we don't, whatever happens when they're in foster care or they're adopted, that's not really relevant to this question.
I suppose I'm trying to find the connection between the injuries that occur and linking it to the placement, because I see them as two different timelines. But I suppose the only response I have is that the allegation is a matter of law, and there's not facts that go into. I mean, if we were talking about perhaps the contract, I suppose it said you will indemnify, you will hold harmless every single person within the Department of Child Services, and that obviously goes to the discovery issues we were just talking about. But those aren't factual allegations that are made in the complaint. It just is a conclusion that there is a legal duty here, and if the court decides that there is one, then it would be a sufficient, complaint allegation. But in our view, it's a legal conclusion that is putting the framework for the factual allegations that come after.
I mean, I think that's right. This is a motion to dismiss, and, there has been no meaningful discovery, and I think it is certainly an open question whether any of these allegations sort of bear out after discovery and on summary judgment. But just as alleged, I guess, I guess I don't hear you saying that if it is sort of properly alleged that there is this duty and that it was delegated out, that would not suffice to state a state action kind of a claim.
Correct, Your Honor. So our position is that they have pleaded that that is the case, but I think as a matter of pure law, this court has to determine whether that duty exists in this particular scenario, in that we have an interstate placed child who goes to a private adoption agency placed by whomever, whether it be Franklin County or the South Carolina Department of Social Services, and then is placed again in the care of private individuals that are not, as I said, not state foster actors, so to speak. And we think that that cuts the custodial relationship that Doe discusses, and this court hasn't made that distinction and hasn't narrowed that focus from Doe to discuss whether placement from basically 3 levels of Department of Social Services to a private adoption agency to a private family, if that duty maintains all the way through.
But they're not saying it goes all the way through to the Mitchells. They're just saying it goes one step from the state to the worker that the state contracted with to do what would otherwise be done by state employees. We're only talking about the one level, I think. I mean, I don't read the complaint as alleging that the Mitchells are state actors, but maybe you read it differently.
Well, they're alleging that the harm that the Mitchells.
That's sort of a question of damages. If you can prove that the placement was made with deliberate indifference, then you have a damages question, but I don't think that turns on anybody's state actor status.
Sure, and for us, the placement still is placing them into a non-state custody. That's essentially our argument. When we talk about West and Atkins, we're talking about someone who is physically within the prison system and has a doctor come in and look at them. They have not been removed from state custody physically within a state institution. And Doe uses that term quite often in a state institution, custodial institution. So I think the physical custody is of primary importance when we're talking about when the duty.
So if we assume, which aren't the facts in this case, that the state of Ohio placed the child directly in this case, would the state of Ohio then be discharging a constitutional duty in its placement of the child?
In South Carolina, we think no, Your Honor, because they are placing them with a private family member, or a non-state custodial.
Right, but wouldn't the constitutional duty, since it's a federal constitutional duty, be uniform? I mean, how could it vary from state to state?
Sure, Your Honor. And so because we're talking about acting under, well, I'm conflating private 1983 claims with those of Monell and state governmental actors, so I apologize. But when we're looking through the acting under color of law, and we look to the previous precedent, as Your Honors have noted, there is no private cause of action for purely private harm. And so what we're saying is that the placement with a private family doesn't confer that duty of protection.
So your understanding is that notwithstanding Doe, South Carolina is free constitutionally, South Carolina, their own employees, to place children who are in their custody, in their sole legal custody, have no other form of protection in the world. They are free constitutionally to place those children with people they know will abuse them in deliberate indifference to that risk. Because once they are placed, those people are private. So you think Doe does not prohibit that?
Assuming the facts of the complaint state that, as we would
I'm
in
just
this
asking you
posture,
a
sure.
hypothetical. Is your position that the state of Carolina does not have a constitutional duty to the children in its sole and exclusive custody not to knowingly place them with private parties who will abuse them?
That's correct, Your Honor. I mean, and this court has held that before in the Milburn case.
That is not what the court held in Milburn. That is nothing close to what the court held in Milburn.
Well, Your Honor, those children in those cases were removed and then placed with a familial member, I believe a grandparent, and then the court held that.
The question was whether the grandparents were state actors so that the state could be sued for the harm that ensued after the placement. The question in that case was not about the placement. The placement question came up squarely for the first time in Doe, when I understood this court to say very, very clearly that states have a constitutional obligation to the children in their care and custody not to place them with known monsters who will abuse them.
So if you could
apologize, Your
wrap up, because we've taken you over a little bit, so if you could go ahead and bring your arguments to a close.
Sure, Your Honor. And so we would just be asking the court to hold as a matter of law that private adoption agencies who receive children in interstate compact placements do not have a constitutional duty to protect and investigate, as is alleged in the complaint, under 1983. And just very briefly, Your Honor, just so I can have it on the record, we would also assert a qualified immunity defense if the court were to find state action here. The Filarski case is a relatively recent Supreme Court case that discusses the ability of qualified immunity to enter to the benefit of private parties who do public function or contractual duties for the state. We can rest on our brief for the remainder of that, but I would ask the court to consider that as well. Thank you.
All right, thank you very much. Mr. Butcher, you've got some rebuttal time.
Yes, sir. So, and just thinking about what you asked me earlier, Your Honor, regarding in the complaint, I really don't think, and I can't envision trying to, and I know I pled a lot in that complaint, but trying to plead out all these additional issues with state action. I think we sufficiently allege that they were state actors and that they, Franklin County asked the adoption advocacy people to stand in their shoes and take on these fundamental rights for the children. Going to my second assignment was to get Judge, I apologize, I forgot your name, Your Honor.
I'm Judge Harris.
Harris, these docket numbers, and of course, the court is free to look at the docket, even if it wasn't put into the JA. But docket number 7 is the motion for limited discovery. Number 9 is either 8 or 9. 9 is granted in part and denied in part regarding who these fictitious people are. And then there's a text order right afterwards that says, I need to serve it on BSS, and then the amended complaint comes after. I would ask and warn the court.
Counsel, let me go back so we're sure, because somebody's going to have to write this opinion. The district court ruled at JA 117 that you did not allege that the defendants engaged in an action or that the exclusive means of adopting children was a public function. You agree you didn't allege that basis for being a state actor?
I believe the court said I didn't sufficiently show it in my briefing, Your Honor. That's how I read it.
Where is it in your complaint? Let me ask it that way.
It's not in my complaint, Your Honor.
All right, so the district court was probably right on that point. So then that brings us to the other point, which is, was there a constitutional duty that was delegated to the defendants? And if I'm reading the district court's order correctly and the answers of counsel, the district court never addressed that allegation.
And say the allegation one more time, Your Honor.
The allegation, in order to show that that a defendant can be brought within Section 1983 as a state actor when you have a private party, cases will say that that person can be brought in because there was a constitutional duty from a public authority that was delegated to the private actor, and that can then make them a state actor, and that's sufficient. So what I thought your argument was that you alleged that in paragraph 41 of the complaint, but I'm not finding that the district court ever ruled on whether that was sufficiently pled or not. They just didn't address it.
They didn't address it, Your Honor. They just went straight for, I think overall in the court's mind was that foster care is not.
So that your argument would be is in and of itself an error that the district court didn't address it.
Yes, Your Honor.
Okay.
Yes, Your Honor. Couple other things. There have been a lot of a lot of statements and misstatements of what was in the complaint. And again, there's nothing attached to any of my complaints. And they keep saying that I attached an adoption decree. It's like, we're in completely different cases. This wiggling around with adoptive placement versus foster care placement. My child is a foster child by virtue of either emergency protective custody or a court order. And eventually after EPC, we know a court order is going to kick in. It's only extinguished. My kid is only out of foster care as soon as there's another court order, such as the adoption decree, which occurred on October 15, 2015. My child is a foster child from the time she leaves Ohio in April until October 15, 2015. Frederick County sold this, this child to Adoption Advocacy to supervise the placement, to make the placement, and to make sure it was safe. And, Deborah Thompson in the Doe case was the exact same person over Doe as these folks were. I mean, it is on all fours. It's the same case. And, when I argued this case in 2009, the counsel for DSS stood in front of the panel when Judge Traxler asked him, is DSS responsible even if they know and are watching a child be molested? And DSS said, no, there are no constitutional duties to protect. There are, and they cannot be sold, Your Honor. That's the bottom line with this case. They stepped in their shoes. Any other questions?
Thank you very much, counsel. We appreciate the arguments of both counsel. Normally, we would come down and shake hands with counsel in the well of the court, but COVID doesn't let us do that now, so we hope you'll come back on another occasion. And with that, I'll ask the clerk to adjourn court until this afternoon.
Thank you, Your Honor.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.